like to make some submissions today.
Pardon?
After me, sir.
We are closing the hearing today.
Today only.
Yes, then don't mention. Okay, take your seat. When he comes, he will make his
My
argument.
lord, with leave of your lordship's court, my lord, I am not mentioning, but I am just ventilating my grievance, my lord. We 27 of the petitioners had taken out an application for inventory. My lord, the petitioners are, my lord, my lord, candidates who have been given appointments after expiry of panel.
Sorry.
But my lord, kindly sees, my lord, but
Sorry, sir. We have
one line, my lord, kindly sees, my lord, we have been appointed by order of court, my lord.
Sorry, Mr. Mojumdar. Where is Mr. Mojumdar?
Only one point.
Yes. Come. Mr. Sharnal, you have finished. Yes.
No, my lord, the last point you lost it, Mr.
You have told us yesterday. Yes, Mr. Mojumdar.
That, my lord, something's to be.
No further argument on your part. Mr. Dotto, we have allowed him sufficient opportunity. Yes, Mr. Mojumdar.
My lord, only one thing the clause in the advertisement that he can opt for other counsel.
Who does that?
Losses because the legible copy was probably not there to your yesterday.
For exercising of option, you showed us that.
Pointer দেখাতে পারতো আরেকটা কপি আছে তো বাবা থেকে
আচ্ছা
Now, you losses kindly see these are the advertisement notification first clause. I put a tick mark for this.
Yes.
My lords, may I have my lord's permission to address?
First point number 1. Any candidate shall be allowed to apply for the post of a primary school teacher of a particular council only against the post advertised. Particular council he can choose for the form. And then you'll also see the next form fill up.
No, what is your interpretation? Any candidate shall be allowed to apply.
Any candidate shall be allowed to apply for the post of a primary school teacher of a particular council. The council was not fixed. He can choose any particular council. A candidate of Kolkata council can choose for Darjeeling council. For example, I'm saying, for a particular council for the post advertised. Now you'll also kindly see the application in the next.
Where?
Losses will find after email ID. Your losses will find this roll number 19. 19 stands for District Birbhum code. Roll number. Second column, your loss. Second column. This is state roll number, my lord. 19 stands for Birbhum.
Date you said that there was a unique number.
This roll number was treated all along by the board as unique identification number.
When the number added with this district code.
District code.
Then what is your argument?
Argument is that, my lord, a particular candidate, this number 19 or 18 denotes the particular district he applied for TAPE. Now he has been given option. He can choose another district with this roll number. That's your lordships in this application form. Kindly, my lord, go little down. Email ID.
Yes.
Just thereafter. Preferred district for counseling, recommendation and appointment. If empaneled, he has chosen Kolkata. This particular candidate, I'm giving an example, chosen Kolkata.
All right. Yes.
The next one also. But all in this chart, your losses, most of them belongs to the other medium, or most of them chosen different districts. So number cannot be equal. Cut-off marks, no, last empanel candidate numbers. There is no cut-off number. Cannot be equal. That's our submission. And Mr. Ahmed says all are Bengali media. That's absolutely not correct. Because showing that most of the, I can give example right now to your lordships. Some of them from Bengali, Hindi medium, some of them Urdu medium, some of them Telugu medium, Santhali medium.
All right. Yes, Mr.
Lordship, with your kind permission, Mrs. Arora is online. Your Lordship had said should start.
Yes, yes.
My lords, I'm so grateful. I will be very brief and just to the point because a lot has already been addressed before my lords.
Item number, mat number 1616. Mat number 1616 of 2023.
Mat 1616.
Of 2023.
Item number 28.
Item number 28, Lordship.
20. Yes, madam.
Please, my lords. My lords, I'll be very, very brief and only to the point because there's a lot that has already been addressed and it's no point in repeating the same thing all over again. My lords, the very first point that I wish to address, my lords, is that right from 1951, the Supreme Court settled a principle that if there is any allegation of fraud, coercion, duress, etc., is to be made in any pleadings, this thing, it has to be supported in material particulars. And
Yes.
there, my lords, there are two judgments of the Supreme Court. My learned colleague will pass them on. I will,
Madam, you reply, we will take note of. Further
please.
cannot.
Yes, my lords, I will just give the citations and I leave it with the paragraphs. My learned friend will just mark the paragraphs and give it to my lords. I do not wish to this thing. Now,
Yes,
my
you-
lord,
please
right in 1951, the Supreme Court said that if there is an allegation that is made in respect of fraud, coercion, duress, there has to be proper case. It has to be supported in material particulars. I will just read 3 lines of that judgment of 1951.
we accept your argument. It has to be.
I am grateful. I am grateful. My lords, I need not go further. Now, my lords, I respectfully submit that the writ petition, as was filed before this honorable court, of which the impugned judgment is the one which is under challenge before my lords, is bereft of any material particulars of so-called corruption or any kind of particulars to show that there was some case that was made out which would clearly establish that there was a corruption or there was a fraudulent action on any of the candidates. This I go back to the learned single judge. My lords, my next submission taking up on this is, and I say this with all humility at my command, and I don't intend to be rude, but if we look at the judgment of the learned single judge, my lords, it appears, and I say this with humility, and I repeat that, it is like prosecutor and judge in one. And that, my lords, is definitely not permissible in a rule of law. First of all, there was no material. The learned judge relies upon some sampler material, which the learned judge finds. So he takes on some kind of an investigation, and then he carries on the cross-examination of certain interviewers by himself, to which none of us who are the affected parties were a party or could have even asked any question. And on that sample material of about 30 odd investigators, and something like, I did a calculation of the numbers of the candidates in respect of which the learned judge has observed, is 0.03% of the total candidates who had taken the exam. And on that basis, the learned judge arrives at a conclusion that there is far-reaching corruption and the entire exam of 32,000 who had been appointed should be set aside. My lords, today, when we are before my lords, the assumptions and the presumptions that the learned judge proceeded with have now been found to be incorrect in view of that charge sheet that has now been filed, where none of these allegations of corruption against any one of these 32,000 candidates has been made out. So, my lords, at the first instance, entertaining the petition was completely wrong, contrary to the principles that the courts have held in the cases of fraud, duress, coercion, etc., no material particulars. In a writ jurisdiction, the honorable judge could not have become an investigator, prosecutor, and a judge by himself. And in any case, the observations and findings of the learned judge have today been disproved by investigation, by an agency which has today investigated and found no allegation against us 32,000 odd candidates, my lords, and there is nothing which is against them. Now, my lords, I submit that's my very first point on the background that I wish to place before my lords, that in view of this fact today, after having put in more than 8 years of service, to say that today all of them should be, my lords, asked to go would be extremely harsh and punitive without there being an iota of material or evidence on record. On the contrary, the contra evidence is there on record. Secondly, my lords, I believe, and that is what I have been instructed, that there has been much emphasis to connect this matter with the 269 TET candidates who were given one grace mark and the 94 other participants who were not qualified. My lords, I would most respectfully submit that both those matters are today's subject matter before the Supreme Court, number one. And hence, this court, with due respect, may not want to go into that particular issue once that is seized off by the Honorable Supreme Court. My lords, number two, neither the 269 nor the 94 form part of us 32,000 selected candidates in this process. Now, clearly, if they are not a part of this, I fail to understand in what context is the reliance being placed on those particular candidates who are not part, who do not form part of V32,000.
Now, why do you say they are not a part of that? Because
My lords, the 32,000 who have been selected here, these are the ones who have been through the process of having the qualification of TET exam. So the 94 clearly do not have the TET qualification. They are the ones who are not qualified.
no, you have given candidates appointment by giving a grace mark.
I agree. But my lords, these
That
32,000,
applied in respect of all the persons.
my lords, no. So far as we are concerned, there those people had not qualified the TET. They were given one grace mark and made to qualify. But here in our case, all of us are TET qualified. We didn't need any grace marks to be here. We didn't need any grace marks to have qualified this particular exam. We came on our own merit. We had the necessary eligibility and the qualification. Our documents and our papers were verified, and thereafter we were subjected to the interview as well as, my lords, the subject matter of our ability to impart education, the two tests of 10 marks each, 5 marks each, we were subjected to that. So, my lords, we are not in those category at all.
What about the 94 you were saying?
My lords, 94 are the ones who do not have TET qualification at all. They are not qualified. Their case was they were unqualified candidates. They were not TET qualified. They were only trained but not TET qualified. And by which time the NCTE had clearly made that TET was an essential qualification for purpose of appointment of teachers.
All right, madam. Anything else?
So, my lords, just two more very small points, and I will not dilate too long on that. My lords, issue were raised to say that the Tripura judgment, and there is similarity between the Tripura and the present matter, and in the Tripura case, the High Court had actually quashed all those appointments. My lords, I want to say there are major distinctions between the Tripura case and this case. First of all, in the Tripura case, there was a challenge to the constitutional validity of employment policy of that state itself. And my lords, that policy was contrary to the NCTE. Now, that is not the case before my lords at all. There is no constitutional validity challenge to any provisions or any rules. Number two, in the case at hand before my lords, the appointments are strictly as per NCTE guidelines, so far as qualifications of the candidate, etc. are concerned. In Tripura case, in facts, the procedure was contrary to the provisions of National Council for Teachers of Education Act, which is a very important factor. Now, my lords, in our case, all the candidates have qualified, who are appearing before my lords, have passed the eligibility TET 2014. So, and after that, our academic marks were computed on a proportionate basis. We underwent the verification of all our documents, scrutiny, etc. And then, my lords, we participated in the interview and the aptitude.
Yes.
But in the Tripura case, my lords, there was only one interview that was conducted and nothing more was done. And it was a highly discretionary thing, which there was the finding of the court, but more particularly, it violated the NCTE guidelines, which are the central government guidelines for appointment of teachers. So one could not have gone contrary to that. One could not have gone contrary to the qualifications prescribed in the NCTE guideline. My lords, so far as the appointments are concerned, as my lords have now seen, and that chart sheet has been shown very extensively to my lords, there is no illegal appointments that have been found. Whereas in the Tripura matter, the selection and the appointments were found to be illegal. On the contrary, the learned single judge, based on a small data, a very, very small data, which was in a very summary inquiry, if I may say that, in a very summary nature. My lords, in a 226, one can't have an inquiry. 226 does not envisage that kind of an inquiry. Today, there is an investigation and a detailed inquiry, and which has categorically found that, my lords, there is no element of corruption, there is no element of complicity or to corruption here at all. My lords, the third point that I'll be very, very quick with is that a lot of parity was sought to be drawn with the SSC case. Because in the SSC case, the Supreme Court had set aside all the appointments. Now, there's a huge distinction and they're completely different and distinct. My lords, we must remember that in the SSC case, there was a written exam. Here, we have an interview and an aptitude test, and then we have a prior TET qualification, verification of our credentials, our documents, and thereafter we go for interview and our aptitude. In SSC case, I beg your pardon. My lords, that's my Delhi pollution showing up. So, my lords, in the SSC case, there were OMR sheets. In the OMR sheets, it was found on a fairly large number that there was actual manipulation. There was a CBI inquiry. The CBI inquiry actually reported manipulation of the OMR sheets. Now, my lords, please contradistinct that with the present case. In the present case, there is no written exam. There is no such manipulation of any answer sheets. And the investigation today has submitted a report which does not show any complicity on part of the candidates. So, my lords, to draw a parity or to draw anything from SSC exam, my lords, would be, SSC candidates would be completely, my lords, misplaced, number one, and will not fit into the present case at all. That's another fact situation altogether. My lords, lastly, I would want to make a submission. My lords, there has been that can number 2 and 3, where certain
Yes.
documents are sought to be placed before my lords for the first time. My lords, apart from the fact that it has been said on this side that those documents are forged or they are not documents which are correct in nature, but I would, my lords, ask myself a question. At this stage, in an appeal, would my lords, without having any verification of those documents, allow such documents to be placed before my lords and to be considered? Then, my lords, I would most humbly submit to you that we fall into the same trap as the learned single judge did, because he went on the basis, and I would say that with all humility, he went on the basis of what was produced before him. And that has today been disproved by a detailed investigation. Similarly, these documents, which are sought to be placed for the first time before yourself, having not been verified, not been authenticated, and specifically being alleged by the present petitioners before my lords as being forged and fabricated documents, I would request, my lords, that the court may proceed on the basis of the record that has come from the learned single judge, and please do not allow any fresh document or material to be taken on record at the stage of the appeal, my lords. My lords, I will lastly, I would, my lords, there was one other judgment, but I don't think that is necessary, that the honorable single judge could not have gone on the basis of any newspaper reports, because my lords have said it time and again that the courts will not take cognizance of an issues merely because they have been published, and that's not an evidence. That's really not an evidence.
Why you are saying newspaper report? It was not there before the single judge.
My lords, the learned single judge in his judgment and in those proceedings made observations that there's a lot of newspaper publications about alleged corruption and everything else. Now, my lords have held categorically, the Supreme Court held in large number of judgments, that mere newspaper publications are not enough evidence to arrive at a conclusion or arrive at a determination that there is an evidence of, let me say, corruption or something. I'll just give my lords a citation. It's a 2020 volume 16 SCC 811. That's a more recent one. And the relevant paragraph will be 6 in that. My learned colleague will hand over that. So my lords, but that's on the side wing today. It's an outlier, if I may say at best. The core of the matter would be that there is today no material whatsoever to show that there was any kind of a corruption in this particular examination process, my lords. My lords, I'm extremely grateful for your time. I'm very much obliged, my lords.
15 to 20 minutes, not more than that.
Mr. Bandyopadhyay, then you address what Mr. Mojumdar.
Why, my lord, I've addressed first. Your lordship said to me, "Man, I cannot sit here every day.
All right, tell it.
Not sit every day." The my lord, first point that is was hard, but at the initially I have argued that regarding the this extension, relaxation in training, that my lord, relaxation in training was given by the MHRD till 31st March 2016 and 2026 September. There was no relaxation, and the board could not have appointed. This is the argument. Now, my lord, your lordships will find that the rules relating to 2000 recruitment process do you have the extra copies?
2000 recruitment process.
2016 recruitment rules.
Yes, yes.
Yes. The process were enacted on 2nd March 2016.
Yes, yes.
And when the relaxation was still in existence. Okay.
Yes, yes.
Now, Rule 6.3 provided for the appointment of candidates with relaxed qualifications, untrained after the appointment of trained candidates. That your lordship on the paper book, but Rule 6.3 at page 114 of the paper book.
Yes,
That is
yes.
there. If required, I will hand over.
No,
a
it
note.
is with us.
Therefore, relaxation was extended time to time, and within the extended time, all our clients, all these persons who are there, they have what they are.
They were participating.
And to who will get this relaxation? Those who are appointed, not each and everyone. Those who are appointed as teachers.
Yes,
After appointment, they will get it. They get the and they have done it. Therefore, they did not have the qualification. It's not that. And in the advertisement, I have pointed out. I do not wish to again that in the advertisement itself, it was said that this qualification has to be obtained within 2 years after appointment.
Yes.
This is one of
that is not disputed.
that is no dispute. Therefore, we are all trained. Now, my lord, one I have shown it also. Again, I am sorry, my lord, repeating. The Honorable High Court of Calcutta in WPS so and so Chinmoy Doli case permitted the state of West Bengal to appoint untrained candidates. The court's order is there. Untrained candidates as assistant teacher in primary school even after the period of 30.
That is
This is also not this, but they have raised the issue. That's the reason. The point is this, Miller, point is very limited. But with great respect to our learned friends, they wanted to make it more wide. But we do not have to go that such stage. Point is very limited, but they have traveled hither and thither, hither and thither. Naturally, if I don't give the answer, my lord, your lordships will say that I don't have any answer. I have appointed, I do not have given the reply unless the Mr. Bhattacharya had traveled so much. He is my senior.
That will be answered by Mr. Bhattacharya.
He is not there. Mr. Bhattacharya traveled so much. And in practically, he is so from Vietnam to Platinum, everywhere he has traveled.
That is not at least relatable to this case.
No, not relatable. Just Mr.
That-
Bhattacharya is there.
Entire proceeding becomes boring.
Yes, yes. At least two are with us. Compilation. That is, I objected to your lordships. Observe that you will be given the chance. Lord, what is the law of pleading? Even in a writ petition, even law of pleading is very clear.
That you have
Pleading,
extensively argued.
Bharat Singh's case, I have argued that.
Yes.
Because beyond that, no one can go. After completion, Lord, bar from the bar, one compilation will be handed over, which has become very practice of nowadays. And then in that compilation, so many documents will be given. That is not the practice. That is not the law of pleading. That is not the rule of law. In court, we have to be precise with the pleadings and the evidences annexed thereto.
বিকাশের স্ট্যান্ডার্ড চার্ট দেখিয়েছি
Beseech to your lordships, I will request to your lordships not to look into any other documents in this matter, excepting which are in pleading, or which were only in pleading. Even if the learned single judge has committed a mistake,
Yes.
by looking into that documents which are not part of the records, and for that reason which have not been allowed to revert even the other sides, these documents cannot be. And my lord, kindly remember one thing, that the first time we are before your lordships, we are not in the trial court. Though we didn't get any chance. And at the time of argument, the documents are being handed over. How we will deal with? Not a single document.
Yes.
My lord, Mr. Bhattacharya relied on Standard Chartered Bank's case.
Yes.
That is 2006-6 SCC 94.
Deemed pleading.
Yes, was rendered in an appeal under section 10 of the Special Court Trial of Offence related to Transaction and Security Act 1992, para 1. It was a suit wherein the deficiency of the pleadings can be covered by the evidence, but in the writ proceeding being summary in nature, such recourse cannot be permitted. There is a deficiency in pleadings. My lord, every witness have come. There is a scope to cross-examine, etc. Let's assume a pleading has been made vague.
No, it was a case under the Special Act.
Special Act. That's
What
time.
suit why you're saying?
No, Special Court.
Special court.
Section 10 of the Special Court Trial of
A
Offence.
suit.
No, evidence was taken. Evidence was taken. That was judgment.
Evidence was taken.
Evidence was taken.
But it was not.
Not a suit. Sorry. Wrong.
Yes.
Now, therefore, there the evidence. Why this evidence is coming court, regular court, that's a different part. Everyone is getting a chance. then I can ask for this, all right, if with the entry being all persons, I will cross-examine them. My lord, your lordship.
Mr. Bhattacharya's argument, if we are not mistaken, his argument was what are the elements involved in this matter? It encompasses corruption, fraud, etc. So, Mr. Bhattacharya argued that it is a settled proposition of law that suppose A, B, C pleading is required. You have made A and B. You have made pleading as A and B. So, for the specific C pleading, you need not reject it on the ground that there is strictly no pleading to that.
My lord, what is a pleading in a writ proceeding? Can it be vague?
No, on the contrary, your argument is that the original pleading remained. There was no amendment to it.
No.
What was been done? What has been done in this course of action, deemed pleading would not apply.
May I, in short, his case, kindly see what he is asking for, what their clients are asking for.
Yes, sir.
Their clients sought for certain
Similar
considerations. Their clients did not ask for cancellation of any of the employment.
Yes, yes.
Correct. Now, when they have not got it, now they are saying, since I have not got it, soon no one will get it in West Bengal. I have become unsuccessful. Naturally, you will not be no one. And this word is very spicy word, the corruption. Corruption has to be proved. In Bengali, which is called chutney.
Yes.
The point, therefore, is before a lordship, whether before the single judge any corruption was proved.
Yes.
Not a one chain. It is a complete, corruption means a complete chain, not the picking up of the one thing.
Yes, Mr. Bhattacharya.
Now, is there any case has been made out that these my clients have given money and got the employment or not? In the gist.
Yes.
That corruption has been proved. That CBI has said.
Yes.
Some persons have got it. Who are the persons? Dealing with the 32,000 cases. 32,000 persons future. Now, my lord, next one is charge sheet of the CBI. My lord, I have argued extensively the charge sheet of an cited the judgment to your lordships also. Judgment I have cited. It's an opinion only. That has to be proved. My lord, I cited the judgments. I do not want to repeat. Can an opinion can be relied upon to terminate the service?
Yes.
My lord, in our compilation, I have given it 2022.
What is the name?
Volume 12. There is Rajesh Jadhav and another versus State of Uttar Pradesh. Come to Milord paragraph.
Rajesh Jadhav.
I have cited Milord. I have given a separate compilation of
No,
the
no, no.
judgments.
We have taken note of. You have cited Institute of Chartered Accountant, then Khetrobasi Biswal, Boluram, then Ranjan Kumar.
These are different parts.
What did you say? Printers Mysore, Chennai Metropolitan,
This is different.
Murli Babu.
Ogula delay.
No delay. Yes. Now this charge sheet is an opinion you have not given.
No, Milord, I have cited that. Milord, your lordships
Can
will
you
find
give
it.
us the reference, please?
We will give it, get it in my compilation.
2000.
344. My compilation 344. That is at page.
No, the name of
2022 volume 12 SCC page 200 Rajesh Jadhav and বড্ড কথা বলছিস
SCC page 200.
আমি একটু ডাল হেডেড ভাই
Yes.
প্রবলেম 2022 volume 12 SCC page 200
Paragraph.
paragraph milord 27 তাই তো
7.
paragraph 27
All right. Yes,
But I can just want to remind you this proposal. That Section 173 CRPC calls upon the investigator to file his final report before the court. It being a report is nothing but a piece of evidence. It forms a mere opinion of the investigating officer on the materials collected by him. He takes note of the offence and thereafter conducts an investigation to identify the offence, the truth of which ones. Therefore, sir, would be lead to the position that the evidence of the investigating officer evidence of the investigating officer is not indispensable. The evidence is required for corroboration and contradiction of the other materials witness, as is the whole links and presence. Even assuming that the investigating officer has not deposed before the court or he has not corroborated.
yes.
Now, therefore, it is an opinion stage.
It's
Trial has
ten-
not yet been concluded.
It is tentative.
Trial has not been concluded. Therefore, your lordships, the corruption charges have been made. Let's take it. Your lordship is deciding the case in the civil side when charges have not been proved. On the contrary, today, what we see, all the accused have been enlarged on bail. That doesn't mean he has not committed an offense. I'm not saying that. Also, I am saying that doesn't mean the charge sheet is given, that's a sacrosanct.
Yes,
Now, my lord, if the CBI was really serious, take the case, my lord. If the CBI was serious, this case is now pending for 4 or 5 years. They could not have finished the trial.
that is a separate.
Separate thing. But I am saying, my lord,
We understood your.
corruption, we are saying of corruption will not do. That's a separate issue. But I am saying so, my lord. Because these are the very corruption. To prejudice a court is this word is sufficient. But court will look into that, whether corruption has been established or not. That's my
Yes.
submission.
Yes, Mr. Varma.
And the corruption has vitiated the selection process. Maybe corruption, but here the corruption has vitiated the selection process or not.
Yes.
Right? Now, my lord, next.
What do next?
দরকার নেই তো এটা বলা হয় Namely, the litigations for 6 marks have been taken an argument, 6 marks have been granted. Charge sheet has been shown that the 6 marks have been given extra. Correct? That has been pointed out also. My lord, kindly remember, my lord, I can give the references also. This litigation for granting 6 marks, lead matter Pratibha Mondal versus State of West Bengal were moved by Mr. Vikasanand Bhattacharya, Mr. Samim Ahmed, Mr. Sudipto Dasgupta, Mr. Firdos Samin. They got the order from the High Court, 6 marks to be added.
Yes.
And in the charge sheet has said extra marks, 6 marks have been given.
Very good.
কি দরকার জজসাহেব এখন তো চার্জ শিট দেখাতে গেলে তো হবে না it will take time 15.
Yes.
But I will give this orders copy. I will give it to your lordship. Who got this order from this court?
No, Mr. Bandhavia, that is not required because your argument is that it is an charge sheet is an opinion, it is tentative
But-
on the basis of it. That is your
Very
argument.
nice, very nice. I am just
No, as you are.
my lord, I am who is on which side is very difficult now to understand.
To track your point.
For not conducting the aptitude test, then selection cancel of the selection process only for untreated candidate is only bad in law. Untrained, trained, all everything will go. These are practically possible now at this stage to after 2016 to 2025.
Because the trend also faced aptitude test.
Yes, same. Only extra. The trend is also having the certificate. We untrained also obtain the certificate. Therefore, your lordship is facing with the problem. If this acceptance is taken away, then more than 60,000 teachers will go.
Hmm.
42,000, sorry, my lord. Not only us.
পার্টি উনি ট্রেন্ড
Neither untrained was made party, neither trained was made party before the single judge.
Yes.
And unfortunately, Malad, this is a very unfortunate for us. Although the board is represented by here the learned Advocate General.
He has left.
No. I will not blame him because he was not there at the initial stage. Neither Mr. Rahul Ratul was there in the see the proceeding. From the very beginning, board did not contest the case at all. Not a single thing has been said. The counsel who appeared at that point of time.
He put this question to Mr. Dotto. He has.
Our anxiety is that, Malad, everyone was not required to be calm before the court. But when states and the state authorities are represented, Malad, society expects everybody's case will be argued properly.
Yes, Mr. Dotto.
Next point, Milord. Citing examples of few irregularities cannot be ground for setting aside of the 2000 selection process.
Citing?
Few candidates.
Oh, yes. Yes. That you have argued, Mr. Bond.
No, this point I did not argue. They have
Yes.
taken, but it was Lordship's
No
point.
point.
My Lord, it was your Lord's, my Lord Justice Chakraborty's point. Lordships have argued. I am grateful to your Lordships.
No, we have not argued.
Not argued. Your Lordship have, no, Lordships.
No, Mr.
Not argued, not. I am sorry,
Mr.
missing.
Yeah, yes,
Sorry.
Mr. Anindo Mitro and
No, here
that
this
gave the
this observation had fallen from your Lordships.
No observation.
Very good. I am with you.
No.
Very nice. Now, few incidents.
Yes.
Can it be a ground? Few incidents.
Yes, it is.
Then when you are taking the 32,000 employees employment, you prove it 32,000 case.
Yes.
After all, it is a litigation.
Yes, Mr.
Milord, this I am coming. Milord. Documents regarding publication of panel. The writ petition, kindly see. Writ petition itself in 2009, Milord, 19.
Monica Das or Robiul Sheikh.
Niladri Jana.
In the bunch of Robiul Sheikh.
In the bunch of Robiul Sheikh.
Huh?
Here is.
Hard with Robiul Sheikh.
It was hard with Robiul Sheikh.
Oh, it was hard with Robiul Sheikh?
Yes.
Yes. What you're
Brother,
saying?
কোথায় দেখা
Robiul Sheikh and matter.
আরে তুই এখান থেকে দেখা না তুই অন্য জায়গায়
Paragraph 35, 25 and 26 annexure আছে।
ক্যানেক্সারটা দেখা 35 paragraph 35 I'm আর কপি আছে দিয়ে দাও your petitioner says
আপনার জন্য আছে এখানে।
তুই কোথায় কি রাখছিস
Paragraph 35
হ্যাঁ paragraph 35 of this kindly
of Robiul Sheikh. No.
নীলাদ্রি tagged matter নীলাদ্রি
One judgment was delivered, no?
নীলাদ্রি জানা but I am saying the petition
But the judgment was only in respect of Robiul.
common judgment
Please, please check up. I think it is only Robiul.
দেখেন স্যার রবিউল শেখ সাথে নীলাদ্রি জানা।
no Robil Sheikh with the নীলাদ্রি জানা it is there 2023 SCC online page 710
Where you are showing.
Pilot, kindly come to paragraph 35 na?
35
Paragraph 35. Your petitioner states that from the published panel of the district Dakshin Dinajpur, it has been seen the lowest score obtained by candidates are entered is 16,000.436 over the lower course score so and so. Your petitioner states that those marks are higher than. Then, unless you have seen the panel, how can you do it? How can you make this pleading? Next paragraph is
25 26 এ আছে।
25 তো পড়া হয়ে গেল 35 তো পড়লাম তাহলে কোনটা
প্যানেল গুলো 124 থেকে আছে।
Malad, kindly come to page 124 is not readable but see from 124 the panel has been annexed
ইন্ডেক্সে লেখা আছে
panel and kindly see in the index
batch matter list of the photocopy of list দেখো
Malad, kindly come at the top of the
The judgment was it a same
batch matter batch
Achha.
Malad, this is a
Page 124.
yes
Index
This has been
That's
told
the
to us, Mr. Bandyopadhyay, that the panels were annexed with those
Yes.
restrictions.
Therefore, the panel was not published, it was not the case.
No, sir. You publish one.
আরো বেশি বলিস না জজ সাহেব, বেশি চাইছি না। বোর্ড বলে দিয়েছে, এগুলো বলে দিয়েছে বিকাশ করে দিয়েছে। But these are the points, Milord. Almost every other, my other friends have all have dealt with. I don't need to repeat it. Milord, I will just beseech to your lordships, Milord, I will sum up and I will say to your lordships.
Yes.
Kindly just. My lord, these 32,000 persons had been employed, right, for 2016, 17, and 2000 selection for 2017. This is continuing. First round litigation, second round litigation, all have gone. Milord, very recent, Milord, Justice Joymallo Bagchi's judgment, did I cite it? Justice Joymallo, precedent that Milord, one of the judgment I cited that is delivered by in the Supreme Court by Justice Joymallo Bagchi. Binding precedent has to be followed. Litigants should not be forum shopper. Renuka versus State of Karnataka. 2025 SCC online SC 970. Now, when Justice Mousumi Bhattacharya was taking matters, 970, paragraph 17, I cited this judgment.
That was a coordinate versus coordinate, not a single bench versus coordinate.
No, what is the proposition of law has been said?
Proposition is if you are not agreeing with a single judge,
Proposition, binding effective, see, proposition.
that is
That binding effect is there. The one of the word used expression has been used forum suffer, which is applicable in this case. There are a number of judges who have taken the matters of this, not removed. Justice Mousumi Bhattacharya, Justice Amrita Sinha, even my lord Justice Tapobrata Chakraborty was sitting singly. Even my lord Justice.
didn't take up this matter.
No. Education matter you had taken, na? That time it was not moved. I am saying it was not moved. That is, I am not moved. I am saying that. Then Justice Orijit Banerjee, Justice Hiranmoy Bhattacharya, the moment this jurisdiction has come, all that petition, this is called forum shopping. This is what I am not on that. I am not. I am using a legal expression, my
Yes,
lord.
forum shopping. Yes.
Right? Forum shopping. I am not interested in any name. This name has no value now today. Now, my lord, next is. Now, this is continuing, my lord. Would your lordships kindly consider? My lord, consideration before your lordship is this: whether the matter was decided in accordance with law by the court by applying all principles of law. By applying all principles of law.
Yes.
Or whether the single judge has adopted a procedure which is unknown to the settled law.
Yes.
If it is not decided on the basis of the law fixed, it is taking away of the livelihood of others. My lord, 32,000 not before your lordships. 32 into 5. 1,60,000, 70,000 livelihood are at stake.
Yes.
Lord, this is my I am just so grateful, deeply obliged. Your lordships are so kind to me, accommodated me. I am deeply obliged to my lord justice.
We accommodated everybody.
No. Even then, your lordship today. No, I express. At least allow me to express my gratitude.
No, not that. This is the usual practice.
No, I express my gratitude.
You had been serious. Mr. Bhattacharya is there, Mr. Bandyopadhyay. Both of you are senior.
You are, and apart from that, you are so kind.
No, it's about kind.
Your magnanimity kind.
কত তলোয়ার নিয়ে আসছে Mr. Mojumdar, make it short.
I will try to make it as short as possible.
Yes.
Well, first, my lord, I am going to address on the issue of, but other my lord, I will reiterate just a brief recap of my submissions regarding publication of panel. Well, I made these submissions, but just a quick recap. Lordship will kindly take first Rule 2L of the recruitment.
Mr. Mojumdar, we have taken note of
Your
it.
Lordship has taken note of Rule 2L,
Yes,
then Rule
definition.
8.5,
Yes.
then Rule 9, Rule 10, and Section 60, subsection 2, Clause K,
Yes.
which gives the my lord, which vests the District Primary School Council to issue appointment letters. My lord, my submission in short was that, my lord, Rule 2L says that panel will be published according to the rules in the manner as prescribed. There is no prescription by rules in the 2016 rules. So I cited one judgment rendered by the Honorable Supreme Court, 87-1 SCC, page 658. That is B.K. Srinivasan versus State of Karnataka. But this was not in my compilation, but I cited, my lord, I just handed up a copy. 2 copies to your lordships. পিটিশনগুলোতে ওই দুটো পিটিশন, এই একটা তো দেখেছে, আরেকটা ওই কি জানো ওই মনিকাটাতে। Kindly take my lord 87. I have brought copy.
Just a minute.
I am sorry, my lord.
Paragraph 15.
Paragraph 50. Well, I am sorry, my lord. My lord, I am troubling your lordship. Rather, we have tested your lordship's patience to a great extent. But it's like elasticity of your lordship's patience. Paragraph 15. My lord has got that?
Paragraph 15.
15. Man, may I hand up a copy to your lordship, subject to lordship's kind consideration? Which clearly says, my lord, it may be published in official gazette or by any other reasonable means. Here, my lord, since DPSC is the appointing authority and the panel is approved by the board, then it is sent to the district primary council, and the district primary council publish the panels and put up the panels on the billboards of the respective notice boards of the office, in the office of the district primary council. Admittedly, my lord, there are 2 sets of writ petition. One Rubiul Sheikh with 5 others, I believe, right? And another one in 2017, that is Monica Das. Monica Das paragraph ta bola. Just give me that paragraph. Panels were sent. And my lord,
That is in Monica's which paragraph?
Monica's page 16, paragraph 12. My lord, even the it was a lengthy petition, and panel is also annexed. My lord, we have got copies of
That
the
has
petition.
been told to us. That is
Yes.
Yes.
But may I just hand up a copy? Just not necessary or not necessary? কে আছে? কে?
In the writ petition, the panels were annexed.
Annexed. So the panels were available, were accessible.
That Mr. Bhattacharya
Stated that this is not publication in terms of the rules.
whatever has been annexed, that is a list of names, not a
panel. It were panel. Can I take the panels? The panels were published. What does panel would mean? Panel would mean the list of the successful candidates.
Exactly.
Nothing more.
Yes.
We may use different jargons, but this is the upshot of the entire matter. Now,
Yes,
And my lord, in Robiul sake and that batch matter, my lord, this from different districts, different petitioners were there. My lord, from 20 districts or such.
you have given some
I've-
of the read
my lord,
petitioners.
So, my lord,
had
I don't want to waste your lordship's time, and I made my submissions.
Yes.
So, my lord, and my lord, when their turn came,
Hmm.
my lord, this submission was not countered by any of the respondents in the appeal before your lordship, or even the added applicants.
Yes.
There was no rebuttal. Now, my lord, now
Yes, Mr.
my next endeavor would be, well, it's very strange, my lord, just 1 minute of your lordship's time it would take. My lord, the applicants and some of the writ petitioner or some of the other applicants rely on two sets of documents. One, affidavit of agency. I will not elaborate on that. Second, charge sheet till the third supplementary charge sheet. It is very strange, my lord. The applicants on one hand are relying on the affidavit of agency, which is an accused in a criminal case. And on the other hand, they are relying on the final reports or supplementary reports of the investigating agency who is investigating the said accused.
Yes.
So, my lord, in that event, can they rely on any statement made by the accused in a criminal case when my lord, the reports are ready? The reports would speak for themselves. Reports are public documents. And now, my lord, I take your lordship to the charge sheets. I think that will explain it all. Kindly take, my lord, the CRM number. It's part of the criminal case, this criminal motion. Kindly take, my lord, how this investigation was initiated. What is the starting material source of
Mr.
this?
Majumdar, why you are going into
Well,
that?
I have to go into this because, my lord, they relied on this and I want to also rely on that. It's very strange, my lord.
No,
my lord,
here we allowed Mr. Bhattacharjee to rely
The-
since it was a charge sheet
Yes.
can be availed by anybody.
Yes, my lord. My lord, I also want to rely on it.
You
I-
kindly, it was extensively placed yesterday. You
My
were
lord,
there, Mr. Majumdar.
My lord, yesterday supplementary charge sheets were placed.
Right, you tell us the page number.
I will give your lordship the page numbers, my lord, kindly, and I will place somewhat in detail the fourth supplementary charge sheet, which is till now the final charge sheet, which has not been placed at length. Where, my lord, this identity of the 270 candidates or 264 candidates and identity of these 96 or 94 candidates has been clearly specified, and so we know who are those people.
Can you show us that portion?
My lord, I will come to that.
Identification portion?
Kindly.
Because Mr. Dotto submitted to
No, your lordship
that-
doesn't have the entire charge sheet. Fourth supplementary charge sheet, the lordship has got entirety.
Ah,
My lord, certified copy, my lord, I handed over a certified copy of the charge sheet yesterday.
we have ওটা আমার ওখান থেকে আনা many copies we will see.
এই একটা কপি দিয়ে দে ওদের আমি দিয়ে দিচ্ছি তোকে হ্যাঁ করে পাঠিয়ে দেবো কোনো অসুবিধা নেই
This is the fourth charge sheet.
This is the fourth supplementary charge sheet
The-
where, my lord, why I wanted to compare the first charge sheet in the point of time with fourth charge sheet with the fourth charge sheet to place before your lordship or to buttress my contention that what was the allegations which were made initially, most of the Give me 1 second, my lord. Just give me 1 second. Charge sheet টা দিতে আছে।
September 20.
Kindly take the charge sheet. একটা copy দে তো। হ্যাঁ। My lord, kindly take, my lord, first paragraph 9 of the charge sheet, of the fourth charge sheet. Yes. My lord, paragraph 8 would be very important in the sense, my lord, they identify the total number of candidates who got appointment. So all the materials, paragraph 8 at page 17, running page 17 of this document. My lord has got that? Your lordship will find there is a table.
Yes.
Table covering 21 districts and the total number of candidates who got appointment. 42083. My lord has got that? Now, my lord, kindly take 9, paragraph 9. It has already been mentioned in the first supplementary charge sheet that the original as well as the scanned copies of OMR sheets, my lord, these OMR sheets are the 2014 TET OMR sheets.
Those are not with.
Yes. My lord, that writ petition is pending. It is pending in the matter of Shantanu sheet. It is pending before the Honorable Single Judge, where, my lord, the state 2014 examination is under challenge.
Just.
Dao, Shantanu sheet order dao.
No further.
No, it is there. It is there. No further compilation, my lord.
State 2014 is under challenge.
State 2014 is under challenge.
What is the name you said?
Shantanu sheet. My lord, may I give the WPA number?
Shantanu sheet.
Sheet and some others, my lord, Devabroto Das, etc., several writ petitions are there.
In TET, that OMR.
OMR
was
TET
pertaining
2014, yes, everything is under challenge. The matter is pending before the Honorable Single Judge. The Honorable Single Judge adjourned the matter due to pendency of the.
No.
Oh, it has to be taken up. This court is, however, of the view that the propriety of TET 2014 examination would still require inquiry in these writ petitions, irrespective of the proceedings before the Honorable Division Bench. So the Division Bench is this matter.
No.
No, tale konta. Yes, this matter.
That's a very good, sir. Your contention is that was OMR pertaining.
Yes, madam, that is TET
TET
2014.
is, issue is pending before another judicial.
Yes, other
forum. Yes.
judicial forum.
Yes.
So, my lord, in these proceedings, my lord,
Now,
so far
42,000 includes the 38,000.
32,000. Now, kindly take paragraph 9. It has already been mentioned in the first supplementary charge sheet that the original as well as the scanned copies of the OMR sheets were destroyed by Messrs. S. Basu Roy and Company as instructed by WBBPE. Hence, the roll numbers of the aforementioned appointed candidates received from DPSCs were compared with the TET 2014 result seized from NIC. It emerged out that out of 42083 candidates, 431 candidates were those who had not qualified in TET 2014 examination. It further emerged that out of these 431 candidates, 71 candidates were those who had been declared qualified in TET 2014 at a later date on the basis of order of the Honorable Court, High Court at Calcutta, and also after re-evaluation of OMRs. Thus, this is the most important sentence so far as this paragraph is concerned. Thus, only 360 candidates who had not qualified were found to have been appointed. So, now kindly turn over and take paragraph 15. Where, my lord, this 1 mark issue is considered.
Paragraph 16.
15, my lord. I'm sorry, my lord. 15. My lord has got that?
Yes.
May I just read it out? Investigation has further revealed that numerous candidates had represented to the WBBPE and a few had moved with petitions in the Honorable High Court at Calcutta that a particular question, number 6 in the JGB booklet, number 4 in so-and-so booklet in Bengali medium paper, and had 2 correct answers, option A and B, and only those candidates who had marked option B had been awarded a mark, while those who had marked option A had not been awarded the same. It has emerged that on 2011-2017, Mala, kindly mark the date. On 2011-2017, a resolution was passed by West Bengal board. This is the board in a meeting presided over by this Manik Bhattacharya, that such candidates who had marked option A would also be awarded 1 mark, provided that the candidate should be, Mala, kindly take, the candidate should be eye trained. II fell short to qualify by 0.1 mark. III had written the examination in Bengali medium 4 had marked option A. One of the criterion was that the candidate has to be trained. The meeting took place on 20th November 2017 and all my appellants before your lordship were appointed during the period February to April 2017. Long after, when we are already, my lord, we were working as primary teachers in different schools. But the scam, alleged scam, whatever the scam they say, the scam or the allegations pertain to a period which is post-selection, actual selection.
You have said this.
Yes, mother. Now kindly take, it has emerged that a note was put up by Manik Bhattacharya to the Principal Secretary Education Department with copy of the resolution and expert opinion for further processing in ministry. Finally, the note was approved by Partho Chatterjee, the then Minister of Education, Government of West Bengal, on 22, Mala again marks the date, my lord, 22/11/2017. Accordingly, on 30/11/2017, another resolution was passed by WBBPE to the effect that Department of School Education had approved the recommendation of award of 1 mark to the eligible candidates. It is also mentioned in the said resolution that the Secretary of the Board had submitted a note for consideration and acceptance by the board. As per the note, 270 candidates met the aforementioned 4 criteria decided in the resolution dated 2011-2017 and also enclosed the breakup of such number of candidates district wise. It has emerged that no such note of the Secretary of the Board was kept on the file, and the details of the 270 candidates like roll numbers, father's name, etc. have also not been entered in the resolution register. This act shows that the entire omission was a deliberate act on the part of Manik Bhattacharya only to avoid detection and keep the entire act of commission discreet. The district-wise number of such candidates mentioned there as follows. So, Malad, the district-wise number is also there. Now, Malad, kindly takes paragraph 16. It has emerged during investigation that actually 428 candidates fell in these categories and therefore 1 mark should have been awarded to all of them. However,
Mr. Majumdar, why you are placing? It has been the submission. We have taken note that 294, that was 270
70?
plus 94.
Malad, why I am placing
The ultimately your contention is the chart investigation has boiled down to this issue
yes.
that at best if there had been irregularity that is pertaining
Why
to
am-
those 2 categories and we are appointed prior thereto, we are not particular.
Malad, I am trying to, why I am making this submission? Just 1 minute. I am making this submission for the reason that once these candidates are identified, but the names are there, your lordship will find at paragraph 17.
Yes.
Once these names are identified, the candidates are identified, both in the category of 270 and 94. Malad, then there remains not even a cavil that the 32,000 candidates.
You made that submission. Scam at best, if any, is pertaining to 270.
But
plus
at that stage, Malad, we did not have the identity of
that
the
is
candidate.
fortified by this chart sheet
That
which
is
has been
fortified
given.
by this chart.
Thank you.
Kindly
Yes.
take paragraph 17 only. I am not placing. Paragraph 17 for these 264, 270 candidates. Now, Milord, kindly take, goes on. Kindly take paragraph 18, which gives a list of 46 candidates amongst that 270. Then, my lord, kindly
Paragraph
take
18.
18 is, my lord, kindly take, my lord, 18, I am not reading the whole. The investigation has thus revealed that following 46 candidates were untrained when, at what stage? At the time of TET 2014. These 46 belongs to the first category. This 46 is part of paragraph 17. This 46 is part of paragraph 17.
That is 294.
270. So that is why, Malad, I required to place this. That non.
Is that 94 list?
Yes, I am coming to that. Certainly, Malad. Malad, kindly before I take, na, Josh Sahib aage jeta proshno korche seta uttor dao. No. These 96 candidates, your lordship will find at 27. Again, identified. So, Malad, the grain can be separated from the chaff. Unlike SSC, unlike anything. this labeling the entire selection process, or dubbing the entire selection process as a scam engineered process is wholly incorrect in the facts of the case. Now, my lord, kindly take paragraph 28. This is very important. When this 96 were recommended, that's also a relevant date. Whether this happened during our time or not.
Para 28.
28.
Yes.
আসবো আসবো তা যশ সাহেব জিজ্ঞেস করছি টাইম কত শুনবে
28. Yes.
28, my lord. Kindly take paragraph 28. Investigation has revealed that the aforesaid 96 candidates were also recommended for appointment. Vide recommendation letter what? Dated 4/12/2017. So we get 3 dates. 4th December 2017. We get 3 dates. 2011-2017. 30/11/2017.
11 for what?
Yes, kindly take. I take your lordship back to paragraph 15 once again. Kindly take paragraph 15 once again.
Resolution, another resolution.
The resolution of the board. Kindly take page 21.
What are the 3 dates here?
Rather 4 dates. I'm sorry. From at paragraph 15, you will lordship will find 3 dates. One is 2011-2017. This is, my lord, 9 lines from the top of paragraph 15.
Yes.
Right, my lord has got that. Then, my lord, your lordship will another date. That is, my lord, the note approved by Partho Chatterjee. This is 4th line from the top at page 21. 22/11/2017. My lord has got that. Then in the same, in the next sentence, the next date is 30/11/2017. So for 270 candidates, 3 dates are relevant: 2011, 22/11, 30/11. And for these 96 candidates, my lord, only 4th December 2017 is relevant date. Yes. One more paragraph I would like to
4th December
2017, as would be evident from paragraph 28. And also kindly take 22. Just one paragraph. My lord, kindly bear with me. Kindly bear with me.
Yes.
The WBBP has informed that no records regarding interview. Whose interview records are not available? No records regarding interview, aptitude test, preparation of merit list panels regarding appointments of candidates under the resolution of the board meetings for awarding 1 mark are available. So that takes us to 2011, 22/11, 30/11. It has also emerged that these 270 candidates were recommended to the respective DPSCs for issuance of appointment letters. Vide memo number so and so dated 4/12/2017 under the signature of Ratna Chakraborty Banerjee, the then secretary of WBBPE. The investigation has revealed that 264 out of 270 candidates were appointed. Thus, it has been established that these 264 candidates were appointed in a grossly irregular manner in pursuance to the criminal conspiracy between Partho Chatterjee and Manik Bhattacharya under the garb of resolution of the board for award of 1 mark to the withheld candidates, which was approved by Partho Chatterjee, the then MIC of Education.
Yes.
Your lordship will find the same date at paragraph 28, which I have already placed. For this 96 or 90, kindly take once. Page 39, paragraph 28.
Paragraph
28, my lord. That is at the end of the list of 96 candidates. So, my lord, we get a now, my lord, the upshot is this: these 264, the appointments of these 264, the services of these 264 candidates is now protected by an order passed by the Honorable Supreme Court. The appointment of these 96 or 94 candidates is also protected by another order of the Supreme Court. And my lord, the applicants and the writ petitioners want us to go who do not even feature in this list. Well, we do not feature. They cannot say that we feature in the list. And everything happened post April 2017. It is not an exercise which was carried out by the board pre-April 2017. And that would be evident from the first, second, third supplementary charge sheet. One more thing, my lord. If your lordship kindly takes the CRM.
All right, Mr. Ojumdar, we got
Yes.
your point.
Now, my lord, I would wish to distinguish the Tripura judgment because questions came up for consideration. Your lordship was putting queries regarding Tripura judgment. If I am correctly understood your lordship, my lord, subject to your lordship's kind consideration. Because my lord, we cannot repeat in a reply.
No, that
What else?
Miss Arora just now reiterated.
My lord, I will just little
All
more,
right.
little more detail. My lord, kindly take, my lord, the Tripura judgment, which is reported in 2014 SCC online, Tripura 291.
Yes,
And even Mr. Bhattacharya says that this has no application. Well, sometimes, my lord, your lordship will find the parties are somewhere allied.
On the question of law, cannot put.
Well, kindly take the judgment. If your lordship kindly takes the judgment from one side.
no, you give us the distinguishing.
I am giving the distinct and the paragraphs. And the paragraphs of the, my lord, the reported decision. Well, I have got the SCC online version.
No, you give us the distinguishable points only.
Right. Kumar Jyoti দেখিয়েছিল না? হ্যাঁ। My lord, first distinguishing feature is that preference was given to at paragraph 4. হ্যাঁ, ওই পুরো জানে।
আমার অ্যাডভাইস লেগেছে সুপ্রিম কোর্ট।
Give us the points now.
My lord, points is that paragraph 4, your lordship will find that for undergraduate teachers, even Madhyamik pass were allowed to participate, contrary to the NCT guidelines, and even who had appeared in Madhyamik.
Yes.
Then, my lord, paragraph 52 to 66, preference given to older candidates, dependents of the persons who died in harness, dependents of the retired government servants, etc. That was held to be arbitrary because the entire policy was under challenge.
Yes.
One of the most contentious issue, as recorded by the division bench of my lord Guwahati High Court, was that the clause providing for 70% reservation of 70% of the vacancies on the basis of seniority cum merit. Para 68-69. And also a reservation on provision for the persons who are requiring the appointment, economic criteria. My lord, Mr. Bhattacharya appearing for the state made it clear that this is having regard to the minority, the people belonging to the minority. But that was not accepted, whatever. Now, my lord, now, para 85 of the judgment, my lord, the zone-wise selection was sought to be challenged. Then, my lord, in paragraph I, the directions given by High Court, my lord, the directions have been given at paragraph 123 and 124. 123 and 124 are state-specific directions pertaining to the state of Tripura. Then, my lord, in our case, the distinguishing feature in our case that the alleged illegalities crept into the select process post publication of the first set of panel, post selection illegality at the stage of preparation of additional panels. And my lord, the first process was undertaken, kindly mark, because I will not place the paragraphs anymore.
That is not required, Mr. Onma.
My lord, because the CBI found the first process for that 2011-2017, the process for 2011-2017 was initiated in the month of May 2017. 11th May to 16th May 2017, just the pages, nothing more. Kindly take pages, কত ওটা হচ্ছে? ওটা এতে চার্জশিটে কত হচ্ছে? চার্জশিটে? না, চার্জশিটে, ফার্স্ট চার্জশিটে। না, ফার্স্ট চার্জশিটে এটা আছে। মানে pages 107, 108 of the, my lord, the CRM, the CRM. Your lordship will find that. Then, my lord, now ওই যে ওই মানে হচ্ছে তোর এই যে 11 থেকে no, my lord, I had given the final fourth funds.
That we have taken note
Yes,
of.
now, my lord, I am referring to page 106, 107.
Of this.
No, of the initially which was filed on behalf of the applicants.
Yes. 106.
CRM, your lordship was handed up with a copy of the CRM. Page 106, 107, 108. Your lordship will find the relevant date for initiation of this kind of allegedly illegal process took place in the month of May 2017, more particularly from 11th May to 16th May 2017, when we were all appointed. And the final recommendations were made 2011, 2211, 3011, 2017, so far as the 270 candidates is concerned. And 4th December for these 96 candidates. Both 96 candidates as well as 270 candidates.
All right.
So this is there. Now, my lord, I come to a very interesting chapter. Huh? One more. Kindly take page 55 of that CRM for once. This is the first impression of the CBI. My lord, kindly take page 55 from the very beginning. Investigation has also revealed, my lord has got that?
Yes.
An email was sent to the undeserving candidates from whom money was collected. From email, do not reply at primetet.in, wherein it was mentioned that their names were included in the present merit list. However, no such candidates' names were included in the valid merit list or the panel of
This has
WBP.
been told to us by Mr. Dotto.
Then, my lord, so far as charge sheet is concerned, my lord, we stand, our submission stand concluded. Now, my lord, I take your lordship to a very interesting aspect of the matter, which I want to highlight. ওই চার্টগুলো দাও। সেলাই করা তো? Some can, not all, some of them are in service. Some of them are in service.
Mm.
Some of them in service, but the date, my lord, I am not able to say. Date I will not make.
Very good.
Now, my lord, now kindly take this one.
What is that, Mr.
My lord, this is, my lord, this is, I will demonstrate from your lordship, to your lordship, why the subsequent recruitment process, they say that their argument is very queer. Queer in the sense, they say that very well they have been appointed in subsequent recruitment process. That is why they can challenge whatever illegalities have been committed in this recruitment process. They have been employed as a result of the subsequent.
All of them pertain to, do not pertain to 2016.
They pertain to 2016 recruitment process.
They are TET
we do
qualified
not know.
of which year? 12 or 20?
But they are all TET 2014 qualified candidates.
Very good. They have been appointed.
They have been appointed in subsequent recruitment process. They say that we can very well challenge the 2016 recruitment process where illegalities were committed according to them. My lord, kindly now take the writ petition for once. What was the writ petition about?
Writ petition of the
Main writ petition.
those our writ petition.
Yes, my lord, our writ petition. Our writ.
You tell us, it is almost
My lord,
by heart now.
Your lordship, then my lord, I just remind your lordship of paragraph 10, 11, 12 of the writ petition,
Yes.
where they say that all the subsequent recruitment processes were marred by illegalities.
Yes.
Your lordship remembers that?
Hmm.
And now they say that I may have participated in the
I am
subsequent.
beneficiary of that illegal.
And this is the chart which will demonstrate that how the things worked out for them. একটা কপি ওদের দিন।
সবগুলো ইলিগালিটি আছে তারপরে এগুলো তো চালুই হবে ইলিগালিটি
My lord will kindly take that. Because this is what we could gather. Because despite repeated reminders, my lord, despite I made fervent prayers, but the roll numbers of all the candidates, all the applicants have not been supplied to me. This is on the basis of what I could gather, my office could gather, my juniors could gather. And I'm grateful to each one of them.
All right.
Lordship may kindly take the chart.
Chart not required. There's
My lord, it
still
is necessary
contention.
because your lordship will find what has happened.
Even unless-
Because my lord, we are now, my lord, an argument, Mr. Bhattacharya started making his submissions, if I correctly remember, quoting Sir Ashutosh Mukherjee,
Yes.
that truth has to be found out.
Yes.
We are in the search of truth. My lord, my submission to that would be the seekers of truth would also have to take the part of truth, which they have not done so.
Yes.
Because
Yes,
the
what
truth
you are
is
showing in
not-
this?
No. My lord, they are now super sleuths. They don't believe the CBI charge sheet in its entirety. They are super sleuths. They are the super detectives, super investigators. And they want your lordship to convert this, my lord, intra-court appeal proceedings into a kind of, my lord, commission of inquiry. Kindly take, my lord, paragraph, page 1. I will not trouble your lordship with the entirety because this is just for the records. My lord, this your lordship will find. These are all. I have given the details of the names of the candidates and their position and their applicant number in the CAN 3. And also I have, my lord, at the footnote, I have given the litigation history of that recruitment process as a, my lord, as a kind of ready reckoner.
Now, then out of this 140, how many candidates as per your calculation?
My lord,
have
140
already-
writ petitioners. Yes, my lord, kindly take, my lord, page 2.
How many? How many? You must have.
My lord, I've got, I'm giving your lordship. 46.
They are not the writ petitioners.
না রিট পিটিশনারও আছে রিট পিটিশনারও আছে বিকাশ আপনি জানেন না
In this internal page,
প্রিয়াঙ্কা নস্কর herself
Ah.
is there.
petitioners in WPA, this petition who were allowed to participate in 2022.
Who?
How many? If they have participated,
Yes.
does their challenge fail?
Well, they have participated, their challenge do not, well, they should have, my case before lordship is that,
They should have said that.
not only said that, the matter, the entire issue was pending consideration by Honorable Supreme Court regarding this recruitment process, because all these candidates, including Priyanka Noshkar and others, were pursuing DLED course when this recruitment process was initiated. They were yet to complete the DLED course. My lord, by orders passed by this honorable court, by the honorable single judge, my lord, they were allowed to participate. Matter was carried to honorable Supreme Court. The honorable Supreme Court directed the board to publish a list of the candidates and also issue a notice so that they can participate. From that list, we could gather that these candidates are the common petitioners. That list is a public document, and that notice I have indicated at page 1 of my note.
So 46 of the petitioners out of 140 participated in the subsequent recruitment process and were appointed.
Not yet appointed.
Not yet.
Not yet
That's
appointed.
very-
One.
Anything now kindly,
Now, my lord, kindly take and admit and my lord, indisputably 14 candidates from CAN. Apart from my lord, those who had been appointed.
where,
My lord, CAN 3, 14 candidates from CAN. My lord, first table is 14 candidates from CAN because
Yes.
we could not get the roll numbers. Had we got the roll numbers, perhaps my lord, we could have found out more.
so this first 14 and 46, that
First
comes
14
to
is CAN
60.
3, 46 is the writ petition. To the best of our information, and my lord, this cannot
Now these 14 have been appointed.
my lord, again, my lord, it is pending consideration.
Before Supreme.
Not Supreme Court. Supreme Court has issued a in contempt proceedings. Supreme Court has directed the board. The board will be able to say that you immediately complete the recruitment process.
I see.
And all their names were included in the list appended to the notice
Hmm.
of February 2024. 24th February 2024.
Yes.
Second, we have dealt with in a recruitment process wise, because now B, that is page 4.
Yeah.
Your lordship will find
Out of CAN 3, some were parties to the writ petition.
one not party to the writ petition regarding recruitment process of 2020, Ali Hossain Mandal. And this Ali Hossain Mandal not only challenged the entire process, challenged his non-conclusion, the matter traveled to Supreme Court and he failed before the Supreme Court. And that judge, that nothing has been disclosed in the CAN.
No, Ali Hossain is not a petitioner before us.
CAN, in the
He
CAN,
can,
in
not
the
in
CAN,
the writ petition.
not the writ petition.
So this Ali Hossain has what have,
Participated in 2020 recruitment process.
Acha.
My lord, which is again, my lord, paragraph 10, 11, 12 of the writ petition. And my lord, paragraph 50, now his applicant number 58
Hmm.
in my lord CAN 3. My lord, the matter traveled to Supreme Court. Even the judgment is reported in SCC.
Which matter went to
My lord, this Ali Hossain's matter regarding 2020 recruitment.
Yes,
process.
2020.
Yes, I'm saying that. My heading says so. My heading says so.
Hmm.
And my lord, I believe learned advocate general appearing for the board cited this judgment rendered in Ali Hossain's case.
Mhm.
Now, my lord, we come to the C, the third category. This is an additional panel, 5% in terms of Rule 86
Hmm.
and pertaining to, my lord, 2016 recruitment process. Writ petition, my lord, is pending. Na, disposed of হয়নি বোধহয়.
So this Rakesh Mondal petition, they were parties.
Rakesh Mondal himself is here in CAN 3.
CAN 3. Now what you're
My lord,
trying
your
to say-
lordship will find interestingly, in this Rakesh Mondal writ petition, which pertains to, my lord, this additional 5% panel, the agency was directed to use that affidavit,
Hmm.
which has been relied on by, my lord, the applicants as well as some other petitioners, writ petitioners or something like that. And your lordship will find these are the applicants in CAN 3 who were also party in the Rakesh Mondal writ.
চাকরি করছে
fourth category, that is D, which your lordship will find at page 7.
The allegation has been dismissed by the Supreme Court, right? Dismissed by the Supreme.
Yes. Allusion has been dismissed by the Supreme Court. But 2020, well, I made it clear, 2020, I have given the recruitment process. Because all the recruitment process are now relevant, they are challenging
yes.
TET 2014 as a whole, lock, stock and barrel.
Yes.
Now, Miller, kindly come to D.
Hmm.
Applicants in CAN number 3, in MAT numbers, this is our MAT, I mean board's MAT, who were party to the writ petition being so and so, I mean SLP, this matter was also went to SLP, so and so, Motushi Rai versus State of West Bengal. One, Pintu Kumar Guchai, who is applicant number 70 in the CAN. I have given also the history.
Pintu is in Motushi.
Yes, Pintu is in Motushi.
Now, what has been the fate of Motushi?
Motushi, my lord, Motushi has been disposed, my lord, the matter went to Supreme Court, and the Supreme Court, by an order, which is again a reported judgment, directed that the learned judge would consider
Remanded it.
in terms of the Ali Hossain Mondal judgment.
Oh, now it is pending.
Selection process.
This
That
is
is pending.
pertaining to, this is also pertaining to 2020.
No. This is 2016.
No, this CAN 3.
CAN 3,
This clause
Pintu
D.
Kumar Gachayat, the MAT number 42, 44, which I am referring to, your lordship has got.
Yes.
This is referable to 2016 recruitment process. That is our recruitment process.
Then what you want to apprise that?
Well, I want to apprise that this gentleman was a party there. The matter even traveled to Supreme Court. Matter has been remanded back. My lord, Learned Single Judge has been directed to consider the matter in the light of Ali Hossain Mondal's case, which is there. It is again a reported judgment. All these facts ought to have been brought to the notice of this court. But this is one, my lord, I tell your lordship, when we were children, we used to read my lord, Uderzo and Goscinny's Asterix and Obelix.
You are still a child, Mr.
I am still a child. Even still I read Asterix and Obelix. And this corruption is like that magic potion.
Yes, thank you, Mr. Olinda.
My lord,
Yes. Mr. Bhattacharya ji,
would your lordship, one minute?
you want to?
Achha, ঠিক আছে, এটা-
I will take 5 minutes.
Already, sir. Yes. Mr. Banerjee, we have heard any other new point? Reply. আচ্ছা এই ও শেষ করে নি finished.
Our chart, whatever chart we submitted, though that chart could not be disputed by any of them. I submitted a colored chart, remember your lordship.
Yes.
That has not been disputed by any of the.
Yes, already.
I'm grateful, my lord.
Mr. Bhattacharya ji, please wait, let them. Yes.
Why I'm saying, my lord, let us just relax for at least 1.5 minutes. I remember one incident. In one case, because Justice Shishir Mukherjee, my lord, Mr. Tarun Chatterjee is appearing against me. I was for the petitioner, he was for the respondent, opposite party. Now, I started my case. Then Justice Chatterjee wanted to say something. Take your seat. My lord has said, Dr. Shishir Mukherjee is very, take your seat. Then he is not allowed to open his mouth. Then after 2 days, matter is over, I lost this case. Justice Chatterjee came to my room number 3 from note. And tu fee পেয়েছিস? Of course, I've got the fees. আমায় দিল না কেন? Solicitor আপনি কথা বলেননি পয়সা পাবেন না. I cannot take the risk, my lord, at this stage.
No, we have extensively heard it.
No, of course, no. My argument is very
Question of
short.
risks does not
No,
arise.
my argument is very short. I argued, my lord, because I know my limit.
Yes, what you want to give
I
in
will
our-
prepare a short note, my lord, 3 pages. Can you take it, my lord? That's it. I'll file it. এগুলো নিয়ে নাও, জমা রেখে দাও।
reply also no.
No, I've just 3 pages.
No, you give us the points, Mr. Banerjee, that will again.
And the first thing, my lord, as I've already told you, my lord, my case is quite different from the
ওটা
other.
দিতে হবে না, কমলা নোটা লাগবে।
My case is quite different from other cases. I did not enter into the merit for obvious reasons. Goes to the root of this case. Because the law doesn't mean to be mere theoretical abstraction. It is an instrument to do justice. Where I've got the justice? I was not even allowed because I was not implemented the party. Kindly appreciate.
Yes.
So that violates Article 21. My lord, these innocent persons, they are neither involved in any incidents, anything, without hearing them, and everything is gone. So that's why, my lord, if I open this case, naturally, my lord told me, Mr. Manager, we are giving an opportunity. No, my lord, it's a nullity. So we would use the word nullity.
Yes.
Then, so far we are concerned, they failed to show that there is any violation of Article 40. Then, my lord, interview. And so far, interview is concerned, my lord, we are from the Malda district. Nobody was called for. What is the mockery, my lord? And our number? 269. 269. I have
Who appeared for the appellants in 1368 and 1462.
only one.
Huh?
Only one.
Mr. Ashok Banerjee,
1462.
1368 and 1462.
Only 1462. 1462. 1462.
This is what you have said, we have noted.
One four six two. 1462. The number of the teachers.
You are the coming within 32,000.
Yes, that's true, my lord. All of them are coming.
You are the appointed persons whose
Yes,
appointed.
yes, yes, yes. That is not there.
Yes.
And there is no irregularity. No
You
illegality.
gave us 1368 and 1462. However, you are not appearing for 1368.
That is my fault. 1462 only. It is my fault. Only one case. 1462. Judge ki ghatti diya Allah apni. Sunche na. Because my case goes to the root of the case, I have been deprived and I have been punished. And that punishment has been imposed without giving an opportunity hearing. And not even a party. Unless I make a party, my lord, I won't be able to argue my case. That they are totally innocent.
237.
So, the anti-blue flag is a question. So, my lord, they are not involved. No illegality against them, no illegality. They have not committed any wrong. Why they will be punished?
All right.
As well as.
Thank you, Mr. Banerjee. Yes.
One. I'll take only 1 minute. A procedural matter. Serial number.
Very difficult. That is why we requested you 1
I'm
minute.
not
then
arguing
you
on
are-
merit, my lord.
Please wait. Yes, Mr. Mitra.
My lord, I will, I don't know, I don't like to hear my own voice. I know your lordships do not want to hear my voice, but I don't know why these people, my juniors are
After
asking.
this, how can we stop you?
No, but, well, I tell you, lordship, my lord, 3 sentences. My lord, total vacancies was 42,948.
49.
949.
949. And my lord, by reason of notification dated 23rd September 2016, 10% para teachers are to be. So if we calculate 10% of the para teachers, it comes to 4,294.
3205 has been filled up, rest is.
Yes, total number of para teachers is 2770. So as a matter of course, I walk in. This 10% you cannot stop, and these 10% have not been heard. Now, my lord, the second submission I make is this. There has been no argument has been made against us in so far as we are concerned, excepting, I think, one learned counsel has said, and that is with regard to this fraction.
Yes.
That is the only, if I have understood correctly. Now, my lord, I have got only one submission to make with regard to that by way of reply. If your lordship looks into that notification by way of amendment, it said, my lord, if your lordship take the amending, it says, my lord, that marks out of maximum 5 marks, my lord,
Amendment.
this amendment was, so far as
এই ওই
para teachers is concerned,
ওইটা বের করে দাও না।
yes, this is, my lord, 23rd September.
ওই যে স্পাইরাল বাইন্ডিং এ ছিল, ওই যে উপরটা দাও, উপরটা হ্যাঁ।
প্রথম বইটা। Your lordship, can it just takes 2 seconds, my lord, from
We
your
are
lordship.
taking up that amendment.
Yes,
এই মিস্টার বিশ্বাস পেজ amendment at page
amendment কোন পাতায় রয়েছে? Amendment কোন
amendment
পাতায়
is at
রয়েছে?
page compilation you told us yesterday.
না আমাদেরটা না, ওই কম্পাইলেশন এটা।
Well, original, if you-
Amendment notification of 24th July.
23rd September. 23rd September 2016. Well, really, I draw your lordship's attention to two notifications. One is 2nd March 2016 original, which was amended by the subsequent notification dated 23rd September.
Yes, what are you showing, Mr.
2nd March 2017, your lordship kindly comes to that.
They are on 23rd September, you said.
Yes, no, but your lordship is on 23rd September 2016. This has amended, my lord, the earlier one, 2nd March 2016. To 2nd March 2016, your lordship remembers, item number 7 of table A was only the aptitude test. Notification rule 8, sub rule 3, internal page 5. Sub rule 3 is giving it, your lordship, is a table has been given.
Yes.
In this table, my lord, item 7 was aptitude test, 5 numbers. This has been amended in the
Rule 8, which
rule 8, sub rule 3, table A.
Yes, table.
There, my lord, the last one, aptitude test,
Yes.
5 numbers.
That
This
is
was amended by saying, my lord, in the 23rd September,
131 of the my spiral. 131, page 131.
this one.
Yes, yes. 131. Just 131, your lordship will get the reading.
your lordship will kindly, my lord,
That
keep
is
it.
the new rule. That is the rule.
That-
This is amended.
Yes, yes. This is the amended one.
Yeah, just.
And your lordship takes, my lord. Yes. Yes. Yes, kindly, my lord, put a sticker in that because that will be very important.
Yes.
My submission is absolutely confined to this, nothing more.
Yes, Mr.
Your lordship sees, my lord, in the amended sub rule 3 of the earlier one had been amended to say,
2 parts. Teaching experience, aptitude.
yes, aptitude test, and so far as teaching experience is concerned, it's only for the para teachers.
Right.
So para teachers, the aptitude test was not that required.
Yes.
It is only teaching experience. This teaching experience has been also explained. What is it in, my lord, note 6 of that amendment? Your lordship has seen that? There, my lord, the possibility of any manipulation is not there. Teaching experience, if it is over 10 years, it is 5. If it is experience 8 years, 4, like that, my lord. Experience about 6 years, 3, like that. So there is no question of any manipulation. One looks into the number of years one has the teaching experience and puts the mark. Now, criticism has been made, and I am answering that only, that how is it that if teaching experience 5 for 10 years and for 8 years it is 4, then how could that for teaching experience 3.4, 4.8, this can be given? My answer is very simple. I was asking this question to myself. How is it is possible? Possible in this way, perhaps, that if it is, for example, 8 years and 3 months, that amount of discretion has been exercised. He has put this 3, if it is 8 years and 3 months, then 4.3 or 4.1 or 4.2. If it is 8 years and 9 months, it will be 4. That way, my lord, the fraction has come in. Now, your lordship can criticize that. Your lordship can say that no, if it is 8 years or more, it will be 4. It can't be there in fraction. Well, my respectful submission is this, that this is the way it has been done. And this has been done by, my lord, application of mind. And it is not, my lord, it's a question of only fraction, 0.3, 0.2. If your lordship feels that no, it should not have been done, remove the fractions, make it 4. Even then, my lord, I get selected. So, my lord, I am submitting to your lordship, then from whichever point your lordship look at it insofar as we are concerned, there
So
would not have been.
your argument is even fraction is removed, you come.
Yeah, I come in. Nobody will, and my lord, I will not, my lord, enter into the domain of anybody else. And my lord, my submission is this, and this is my grievance, that when
No, you are making the submission because there are excess vacancies.
yes, yes.
No, how we are to treat your submission as?
No, because
That,
my lord,
if as it is excess vacancy, even if you remove the fraction, I come.
yes.
You come within the proportion by which it has been filled.
Yes, of course, because what I am showing to your lordship is this, that if the 10% of the total is 4,294, then any event to 2,770 come in. You remove the fraction, you keep the fraction, whatever you do, we come in. So that being the position, my lord, I am criticizing the trial court judgment by saying that this kind of putting everything in one basket, that was the rotten eggs should not have been put with the good eggs. And this is, my lord, where the learned judge has gone
But
wrong.
how can you find out those rotten eggs?
Yeah, I do not care. I am saying that I am not the rotten egg. If I am not the rotten egg, then I must come in. I do not, if there are rotten eggs, the authorities concerned will sort it out. But for the purpose of getting rid of the rotten eggs, you cannot get rid of the good eggs. This is what I am submitting to your lordship. In Bengali, we call it muri murkir ekdor korte paro na. If you can't do that, then, my lord, in my very respectful submission, this could not have been done. Para teachers should have been kept completely out of this consideration. And in fact, my lord, no criticism has been made. I had been listening very carefully to the submissions of the learned counsel for the other side. There had been no criticism accepting this fraction. I say remove the fraction. Even then I come in. You cannot touch me. So this is all that I wanted to submit, my lord. I don't want to.
Yes, it's good. Yes, it's good.
But this is all that I want. I don't want to increase your lordship's agony. But, my lord, these are all the submissions that I want to. I'm very grateful.
Yes, what you are saying?
But may I hand up this the mat in which I am appearing, so that, my lord, there is no
Matt,
That's 966. My lord. We have not been made parties. We made an application for leave to prefer this appeal, and thereafter I have come into it.
in 1547.
What but 1547 কি আবার? No, 966 only.
Appeared in 966.
966. That's the only appeal I am appealing.
ঠিক আছে। Yes,
Lordship.
what you are saying?
Lord, with regard to today's item number 36, that is MAT 1974.
Who argued?
I'm one of the applicants.
No, who argued? Did you argue?
Within 32,000.
No, did you argue?
No. I just want to say.
Now you please do not add anything.
I'm not adding. I'm
Then why
subtracting
didn't you
something.
argue at that time?
Milord, the arguments are over now, Milord. I only want to draw to your lordship's notice that there are some petitioners who doesn't want to proceed with this appeal. They want to withdraw their name.
Out of 182,
Out of 182 appellants in this appeal, Milord, six of them doesn't want to proceed.
It becomes immaterial.
I understand, but still, Milord, it is my duty to, because they have given us instruction that they don't want to proceed with this appeal.
So we will again delete their name, send it to the department, amend it.
It's not necessary. Your lordship can only record it. I can here and now delete the name, expunge the name.
No, that's over. That
Let it be recorded, Milord.
whichever way the judgment
That
goes, you
goes.
will not be involved. So what is your
No,
problem?
Milord, if the judgment goes against us,
What against him?
Milord, I have left.
You are.
I was. I'm not. No, we don't want to proceed because I'm not in service now. I have
So
left.
you are similar to Priyanka.
No, then we have left the service.
ছেড়ে দিয়েছে তারা আমরা ভালো চাকরি পেয়ে আমেরিকা চলে গেছে আর আমরা 32 হ্যাঁ 32
You are within those 32,000.
We were within those 32s. We don't want to proceed with the appeal now.
So very good. If you have gone.
But we have filed an appeal, so our name may be deleted, Milord. That is what we want.
But sir, whichever way it goes, you will not be influenced in any manner. If we uphold also, you will not.
the service then how will you be
Yes, we see what is it.
I will be tainted if the judgment goes against the appellants now. I will be tainted as if I have got the service by some mischief. Because I have left the service.
Can you come at any sweet will and say this? 4 months we heard the matter.
Yes.
Not
That
as
I was-
now you are saying. Now the court we don't know, it may set aside. I will be tainted. These how
No, Milord, it's not that, Milord. Just the five,
You are-
if the 5 appellants doesn't want to proceed with this, their names can be expunged. That's all what we want, Milord.
only 6 out of 182 আমদিতে
for in which appeal?
1974.
Did anybody address us on 1974?
No, nobody addressed.
You are appearing for all the appellants there.
Yes. There are 182 appellants.
None of you want to withdraw the entire appeal?
No, only 6.
6 of the
Matt, how much?
Milord, MAT 1974 of 2023.
ওটা তো অফিসে পাঠালে এখন আর আসবে না।
point that was
My lord,
One line, my lord, from Mr. Sabir Ahmed's petition.
Yeah, testing. You people are testing our patience. We first thing we said, you could have told it to Mr. Mojumdar. We could have. Yes.
The fact that people can appear in date in one particular district and thereafter opt for another particular district. That will be appearing from their list himself. Kindly sees.
they are not disputing that, Mr. Lahiri. They are not disputing that.
They have made a representation as if only my lord, the
Pune now,
code
Pune
with respect
chhad-
of the date will be guiding. That is the representation which was given to them.
Yes, what is your contention? Tell us.
Kindly sees, my lord, the
No, you tell us now.
case. Mr. Narayan Mondol, who has been quoted as if he has been, my lord, deprived, is, my lord, from 08 code.
Narayan Mondol is which petitioner?
My lord, he has been quoted by Mr. Sabir.
Which petitioner?
My lord, this is in can 4. In can 4 in MET 580, my lord. Kindly takes up this, my lord, they have given, my lord, of Mr. Sabir Ahmed. My lord.
What do you want to say?
Point is that, my lord, they have been, my lord, they have been trying to, my lord, substantiate that the district court will be the determining factor. District court given in date will be the determining factor vis-a-vis the appointments too. That was their point. They have shown Purulia district court 17. Now, in their example itself, my lord, they have quoted one person who is in district court 8, that is Nodia. But they have compared them with another district court, which is of district court 9. So therefore, point is, they are also aware of the thing that a person can give date examination from anywhere in the district, but while participating in the recruitment.
What is the page number of that comparison?
65.
Huh?
Page 65 of the compilation that has been handed over.
By Sabir Ahmed.
Yes, yeah, this one. This one. Kindly see this one.
Page 65.
Yes.
Yes. Where you are showing?
Kindly comes to page 65.
We are in page 65.
Yes. Kindly sees Narayan Mondol, who has, my lord, been shown to appear from 08.
Yes, sir. Narayan Mondol, 08.
Yes. 08.
They have been compared with 09.
09.
Very
09 is 24 Pargana.
Thank you. Yes, Mr.
My basic argument was that this is institutional corruption, started from the initial stage of appointing that company. Yes, Basu Roy Company. Number the specific point was taken that the rules were to be published by the board according to rules. That's the basic rule. Sub rule L. Not done, not has been satisfied, nothing has been produced. Well, as per the requirement of the rules, these committees can only be appointed with the prior approval. I have stated, I am just reminding your lordship.
You stated, Mr.
Yes. Without no approval of the state government was taken. Now, today, Learned Advocate General has produced a bunch of papers, which practically fortifies my submission. The Learned Advocate General has given a chart. There it puts that what action was to be.
That resolution you are showing?
No, the bunch which was produced Learned Advocate General.
Yes, yes. একটু মনে থাকবে যে এটা প্লেস করেছিল।
Now, that page 6 of the internal page 6 of the bunch, which will shows what actions are to be taken by the S. Basu Roy Company, which is a part of a selection procedure.
Yes.
One. And
where it is said, which portion is?
well, kindly come to page 6, the item number 2.
Yes.
It is also submitted that after publication of date 2014 result on so the confidential processor.
That is Basu.
Has been requested to do following jobs. arrangements for online applications for about 125 lakh qualified candidates and collection fees thereof. This is the starting the process of selection. This is post-state. On receiving the online application arrangements made for preparation of district-wise list for scrutiny, verification, viva voce, interview, and aptitude test. Therefore, the entire selection process, my lord, for 2016 was handed over to S. Basu Roy. This is, my lord, the document produced by Lord Advocate General, which I just point out to your lordship. Now, my lord, then kindly sees about the constitution of selection committee. I am nothing arguing new. I am just showing the documents on Lord Advocate General.
But kindly give us a chance to clarify
Page,
this one.
page,
My lord, internal page 8.
yes, page.
Here it appears that one selection committee was proposed. I mean, no document that has been placed to show that the selection committee has ever sat.
Which portion you are saying?
Page 8, agenda number 11.
Yes,
It is proposed
this
that,
was the constitution.
yes, but my lord, no document has been my lord, placed before the court to show that this committee had ever sat.
Yes. Anything else, Mr. Bhattacharya?
And that's all. This I want to point out, and there is no document to show that the government had granted prior approval before appointment of S. Basu Roy and Chaudhary. Well, this is one ground on which the SSC matter Article 14 was invoked and it was set aside. Therefore, this is no question of without individual cases. We are challenging the action of the statutory body. The statutory body has to justify. The beneficiaries, in my humble submission, my lord, cannot improve by any means the actions of the statutory.
Actions of this.
That's all. Also, can you take note? Taken rule 8. This is procedure of selection.
Rule 8,
Not you had taken note.
6, subject to the approval.
That is rule sub rule 5.
Achha, wait.
Now rule that is sub rule 5 of rule 8. Rule 4. And now, my lord, the rule 8 is the procedure of selection. Lordship has seen that. I am not
Just
troubling my lord with that. This procedure, my lord, has never been followed.
Rule 7,
Rule 8.
yes.
Rule 8, my lord, this is the procedure for the selection. The selection committee shall make.
Selection committee. Yes.
And my lord, there has been no publication of merit-wise list. The entire thing would have been solved not had they produced the broadsheet of selection committee and the panel. In absence thereof, my lord, I think no argument can stand to justify these appointments. And lord, the affidavit filed by the S. Basu Roy Company, which I have placed, my lord, that has also not been controverted by any affidavit by anybody.
All right. Thank you, Mr. Bhattacharya.
Yes,
Ashu,
Mr. Lord.
the learned
One
advocate
clarification,
and the
may I give
respective
one
parties
clarification?
have
Before your
concluded
lordship.
their argument. We cannot allow at this stage.
My lord,
We
they were
have
appointed
reserved
by orders.
judgment.
Well, I understand, my lord.
Sir,
but they
you
were-
could have- we cannot.
I understand, my lord. My lord, kindly.
We are sorry, but we cannot do that.
These persons have been appointed by orders of this honorable court, my lord. That is the whole difficulty. That is the whole grievance of this petitioners, my lord.
Who are
My lord,
appointed?
these persons who are trying to ventilate their grievances before your lordship by way of this application as an inventor, my lord, they were appointed by orders of this honorable court. The 27 of them in the district of Uttar Dinajpur. That is the reason we have taken out this application to ventilate this
This
point.
has nothing to do with.
You are within the 32,000. Yes.
And unfortunately, I have been placed in 32,000 category, even if I have been, I am a trained candidate and
Then
appointed
you-
by orders of this court.
The specificity is not important here. Let's.
Well, we have assailed this in a writ petition, but well, any orders could. But we have taken out an application already. Well, it is there.
High Court had never
Yes, we have
passed an
taken out
order
an
of
application.
appointment.
Can one court
When,
two?
when, sir? When you have taken?
Well, very recently. It is not in the list.
Not
that
in
is
the
the-
list.
the-
How can I do? Sorry, miss.
It is
Yes, chalo.
There are two cans, my lord, can 13 and can 126.
Uh-huh.
My lord, there are two cans, my lord, can 13 and can 126. Kindly, my lord, dispose of this two cans, my lord. They are similarly situated with Priyanka Nashwal.
We will be delivering the final judgment.
Yes.
That will be binding upon all the interveners, all the parties added, writ petitioners, respondents, everything. Naturally, the
Can record, my lord, can 13 and can 126, my lord.
what we will record, madam,
Can dispose of
that
this.
will be there in the cost title.
So this, my lord,
But
allow
Baba,
this
that
can-
is an addition of party application.
Yes, my lord.
We are disposing of the entire matter. Your application will no longer remain. Chalo, দেখো। Objection if this is taken on record.
Let everything be taken on record. In Muhammad submission, Lord, to avoid, Lord, in future
We have
complaints.
no আচ্ছা, আসুন। তাহলে
বিকাশ দাকে তো এটা বলতেই হবে এভরিথিং, বিকাশ দা কিছু নেই তো।
মিস্টার
ওটকে তুমি মিসগাইড করো না না স্যার, একদমই একদমই।
the writ petitioners there were the applicants here.
yes,
You have been granted appointment when?
my lord. In the after expiry of this panel, up to
তাহলে
20,
এরম লেখো, they have been এত applicants have
No, no,
been
say that-
granted appointment
এই তো
on the basis of an order dated 30th November 2017,
page 64 is the first appointment letter.
30th November 2017, passed in WP 15864 WO 2017. Mr. Bhattacharya was right. He said that this is not an order of appointment.
Yes, my
This
lord.
is a consideration order. That is what he is
And my
pointing.
lord, and kindly sees the subsequent pages, my lord.
So, we have recorded your submission. Find out if we have recorded your submission, you for the applicants in those matters, which that application is treated as on days list. When did you file? Today?
Today.
No, not today.
What is the date?
Yesterday, day before yesterday.
Day before yesterday has a date, na sir? Give us the date. You must have filed it. You must have affirmed it today.
No, no, that.
ওটা যদি আনাতে পারবে application টা।
আমার নামটা হচ্ছে 142.
Registered as today. Online showing, my lord, it is registered today.
আনাতে পারবে?
নামটা
Item number
52 page.
Mr. Joyন্ত Mitra has big submissions. I just adopt Mr. Mitra's reply. Item number 42 and item number 9. Part of item number 9 is paragraph. I just indicate this that I have adopted. That's nothing. Item number 42 today para teachers, all of them. Item number 9.
Just
Sorry.
You are in which? You are in application number.
Application number.
You are appearing for whom?
For the appellants in item number 42 today, for all the para teachers. All the appellants in item number 42 are para teachers.
What is the number of the appeal?
MAT 13, I'm sorry, 913 of 2023. And in MAT number, item number 9, MAT 1368 of 2023, some are para teachers, some are non-para.
Are you appearing for
Yes.
them?
These are my two matters.
The other appeal?
MAT 1368 of 2023. Some of them are para teachers, some are not.
Anybody else? Anybody wants to make any line or add?
Not one clarification which Mr. Lahiri has argued. My learned friend has said that I have taken the number, the district code,
Other district.
but the first page 60, I said there are 427%, 486% who have got lower marks than me, and I could find 17 name of the person who have been appointed in Purulia district itself.
Yes, what is your argument?
My argument is that in each district, despite they have
How many persons appointed according
17 in Purulia,
total number of persons?
27, 486, sorry, 486. I've given it page 60.
486 appointed.
And I could only find
All of them have secured less marks than the candidates who have been appointed.
yes. No,
Who have,
less marks.
sorry.
And I could find name of 17% who is working in the same district. Now, my lord, everybody has produced
Don't give
document.
any further copy. We are you are appearing for which
Can-
can did you appear?
Can 4, my lord.
Can 4 and in the list which you have given, you have stated 486 candidates.
Page 60.
Page
60.
Yes, page 60. What you are saying?
So
You
far,
don't, what is your statement? 486 persons grievances that you have not been given appointment.
but this
Though you have secured more marks than the persons appointed.
Mal-
This is your contention.
and Lord, I could find that
Well,
so
the
far,
medium is important.
Lord, yes, that is what I'm saying.
Wow.
Lord, out of Lord, since my learned friend has raised that medium and they have opted for a different district, I could find, for the time being, I could find 17% who has got lesser marks in Purulia but have been appointed. I've got the list of those parties.
Then 400 now 17.
No, my lord, I say, Lord,
I can deal with that.
fine now.
Fine now.
Let them. No, all cannot migrate, my lord. All cannot migrate.
For the district of Purulia.
No.
Who applied in Purulia?
Yes. One candidate in Purulia, but there are many candidates but from different districts. But in all districts, there are, but I have given that comparison chart where less meritorious.
Securing less marks than you have been appointed.
My lord.
No, it
That's my contention was.
One more submission, my lord. Only, my lord, before rising, my lord. Before lordships of desire, my lord. Once, in addition to Mr. Ahmed's submission, my lord, I put one candidate where the same code, the 09, that particular code for district. It is not that the different code or different district they are coming. I got this lady.
You are opposing that statement.
Statement.
Don't give any further
In
document.
support of the statement.
Opposing the statement made by
Yes,
them. Yes.
my lord.
Thank you.
In my case, my lord, I have preferred writ petition. In the writ petition, they have filed a report disclosing our score and the cutoff, and it shows that we have secured more marks than the cutoff score. my
All
lord.
right.
But I have two applications, but here the applicants could not participate in the interview process because their result was published at the belated stage pursuant to the order of the Supreme Court. Even if my interview score is not added, even then I will be qualified. Without the interview marks, I will be qualified.
Filed a writ petition.
Yes, writ petition is pending.
Your writ petition is pending. Very sure.
Get good.